Hey folks, Dale Davidson here. They call me the VA guy. I've got a letter I want to share with you today regarding mental disabilities and timing of claims and how those things can kind of interact with each other. So without further delay, let me talk about this letter. And so, dear VA guy, the father of my daughter was a U.S. Marine and he served from 2006 to 2010. My daughter was born in March prior to her father's death. The father suffered from PTSD and filed a claim for service-connected PTSD, but died prior to receiving any award. My daughter's father went for a PTSD exam and the VA diagnosed him with ADHD, not PTSD. I'm doing the best I can to raise my daughter alone, and on behalf of my daughter, I applied for accrued benefits from the VA, but they denied me. Can you help? Well, let's talk a little bit about accrued benefits. Accrued benefits are periodic money to which a payee is entitled to at his or her death. So in this instance, your daughter would be entitled or may be entitled to accrued benefits based upon an existing rating or decision based upon evidence in the file of the VA at the time of death. And those benefits are due and unpaid. So accrued benefits shall, not may, but shall, upon the death of the individual, in this case the veteran father, be paid to the living person listed below. Spouse, we don't have a spouse here. Children, we have a daughter, okay? Or the veteran's dependent parents, okay? So here we're talking about accrued benefits being payable to your daughter. So you made an application for benefits, for accrued benefits. But there's a timing thing here. An application for accrued benefits must be filed within 1 year after the date of death of the veteran. A claim for death pension, compensation, or dependency and indemnity comp, DIC, is deemed to include a claim for any accrued benefits. So if I had a compensation claim out there and everything was complete, but I just had not been awarded, so to speak, then any accrued benefits would go to my family, my spouse, or my children, or my other dependents if they filed a claim for those within the year. So since you're the mother, okay, and the custodian of the veteran's surviving child, you were entitled to file a claim on behalf of your daughter. And you did, okay? The question is whether you filed the claim for the accrued benefits within 1 year of the veteran's death. So here's where we get into the timing issues, okay? Which is these timing, it's critical. I mean, you have only 1 year, okay? So the initial application for DIC must be filed within 1 year of the veteran's death. So my suggestion is check your dates carefully. If you missed the 1 year date, you're out of luck. I'm sorry. But let's assume that you timely filed. So what's the next step? So a veteran's death after service will be considered to have been due to a service-connected disability when there is evidence that the service-connected disability was either the principal, primary, or a contributory cause of death. In your letter, you didn't tell me what the cause of death was, but that's critical. What does the death certificate say? If the immediate cause of death was, say, for example, a car accident, how would that be related to his PTSD claim? In other words, the cause of death has got to have some kind of connection to a service-connected PTSD claim or whatever claim that you're making, okay? So at the time of the veteran's death, service connection would have to have been in effect for PTSD, or else, again, you're denied. Now, service connection for PTS requires medical evidence diagnosing the condition. So this, again, we talk about nexus, a link established by medical evidence between the current symptoms of PTSD and your in-service stressor. For instance, witnessing your buddies being killed, witnessing dead bodies. That's a service stressor, okay? So there's got to be credible supporting evidence that the claimed stressor occurred. Now, if you were in a clerk typist, for instance, and you were in an office, paper cut doesn't get it, okay? You've got to have some kind of stressor there. What did you witness while in service to cause you such stress, such traumatic stress? Okay. So again, we look at what did you do during the service, your time in service? What's your stressor? Do those things add up? The VA takes a look at the veteran's medical records, as they are highly probative, both as to the veteran's subjective reports, what happened while the veteran was in service, okay, and their objective findings, okay. The VA medical records are generated with a view towards determining the veteran's then state of physical and mental fitness, okay, and what's the diagnosis, okay. So they're looking at the whole picture, okay. Generally, what happens is the VA looks at the treatment records, and likewise you need to examine the VA's treatment records to see if the veteran had a PTSD screening test that revealed positive findings based upon the veteran's self-reported answers. Again, what caused his PTSD? What's the stressor? Is there anything in his military records that would indicate that he actually incurred that stressful, traumatic situation? Was there a PTSD diagnosis by a competent medical provider? That's critical. So in this case, and I'm not seeing it in your letter, but it appears that a VA psychologist did give an opinion that the veteran did not have a diagnosis of PTSD, but that it was ADHD, which is different, okay? So in order for that doctor to have given that opinion, he or she would have had to review the veteran's treatment records and see if there's any formal diagnosis of PTSD in the past, or exactly what was the veteran diagnosed with. So it's a pretty in-depth diagnosis, okay? So when deciding cases, the VA medical opinion is given a lot of weight because the examiner would have considered everything in the file. That's the VA's evidence. What's in the serviceman or woman's record, both the medical records as well as service records, all their records. Is there any evidence referring to the veteran's PTSD or claim of PTSD? They're doing a really in-depth review of everything. They're going to look at psychiatrist records, all of those things to detail. They're looking at evidence. They're trying to develop evidence to support the claim of PTSD. In the absence of proof, evidence of a current disability, you don't have a claim. So yes, the VA has to balance evidence, but in this case, I'm not seeing any evidence from your letter that would support a claim for PTSD. Now, certainly the veteran was not, and you're not competent to provide a diagnosis of PTSD. It's the veterans and the VA's medical records. We're looking at are there any diagnoses contained in those records to show that he had PTSD. Your letter said that he had been diagnosed as ADHD, but that doesn't rise to the level of PTSD. So significantly in this case and in your case, and unfortunately, I don't see any competent medical evidence that has been given to the VA to support a finding of PTSD and then if there was a finding of PTSD, how was that PTSD somehow connected or related to his death? That's probably why the claim was denied, unfortunately. Hey folks, thank you for watching today. Appreciate you being here. Hope you learned a lot. I've got this companion video. It's called Win Your VA Mental Health Claim with These Tips. It kind of goes in line with what we talked about today with this letter to the Dear VA guy. Click on that link, go check it out, and tell me what you think. Until next time, be blessed.